So we just talked about the ways in which civil liberties and civil rights might actually conflict with one another, going back to the idea of the struggle for democracy in Chapter 1. But another way in which civil liberties might conflict with the democracy standard is that civil liberties might actually conflict with our need for security, our belief that maybe there are times when the government should restrict some of these individual liberties that we are the most proud of. And some argue that's a bit ironic because those are the core American values we feel are being threatened and are willing to give those up in order to protect ourselves and our society. Benjamin Franklin recognized this, and he was at the U.S. Constitutional Convention, or the Constitutional Convention in 1787. And he made the observation that those willing to give up essential liberties for temporary security, and his observation is one that says that there are individuals, we the people, popular sovereignty, who these important liberties because we have this desire for security. And so the solution that he proposed and the framers of the US Constitution used was to say we should restrict the role of we the people in making those decisions, knowing ahead of time that we'd be willing to make that trade-off. And in his opinion, making that trade-off means that we shouldn't be involved in that decision making. And so what they've done is that the US Supreme Court, which is responsible for interpreting the US Constitution, including the Bill of Rights, which is the list of the civil liberties that are protected in our political system, is going to be decided by the people who make up the judicial branch are nominated by the president and confirmed by many. So in that sense, the solution was we don't get a say over that. To take and move the judicial branch out of the idea of popular sovereignty. And you can certainly call that undemocratic, but he argued that that limits that part of democracy, but increases significantly the protection of civil liberties, which are an important part of the democracy standard as well. But your textbook also talks about that this is not just a theoretical debate, but it is one that is ongoing because of the debate over government surveillance as part of the war on terror and whether or not that undermines core principles of America, particularly important civil liberties. And the textbook does a really nice job of laying out the types of powers that the United States government gave itself, and in many ways gave itself because we the people demanded it or didn't demand it to stop when we found out eventually that it was going on. And so the USA Patriot Act was passed after 9/11. Part of that is Section 215. Section 215 argues that government can collect any material related to a terrorist investigation, which meant that because the scope of a terrorist investigation increased significantly because this was a global war on terror. It was going to happen around the world. It was going to happen in the United States. It was going to include terrorist organizations be using money from illegal drugs and from gun sales and things like that. The government could then use those expanded powers to investigate a whole range of potential crimes and potential threats to us. And the textbook points out as well that the National Security Agency would use a system for data mining to be able to basically wiretap the data optic system to be able to get information about what people were searching online. And they said it was metadata. It wasn't associated with any particular individual, but that information could be used to invade people's individual privacy in terms of what sort of things they're looking at online, who they're contacting, who they're emailing, and things like that. So the potential threat to particularly this idea of privacy is one that eventually has led some individuals to be concerned about this and to demand some action. And so eventually the USA Patriot Act and the actions taken by the government more completely was modified a bit in June of 2015. So there were changes made to the USA Patriot Act so that a coalition of liberal Democrats and libertarian Republicans forced changes to limit the powers of government, although it has not been completely limited. There are still ways in which using an ongoing terrorist investigation can still allow the government to have considerable amount of authority that can violate individual privacy in ways that make people a bit concerned. And so underlying this is this issue of privacy and the right to privacy. The right to privacy, as we've talked about before, is not in the Bill of Rights. In fact, that was one of the concerns and one of the examples that we used to point out the concern that Alexander Hamilton had about having a Bill of Rights in the first place. If you have a Bill of Rights, you're listing out the individual liberties that are protected. in doing so, you may actually miss some. And in this case, some argue that privacy might be one of those things, that in a modern society, particularly, a right to privacy is so important, and yet we don't have that right to privacy protected nearly as much. It is not one that is completely unprotected. There are ways in which we do have a right to privacy, and these were actually established, as your textbook points out, they were established by the US Supreme Court in some important court decisions in the 1960s and the 1970s. In 1965, Griswold versus Connecticut was dealing with the issue of contraception and whether or not a woman could talk with their doctor about contraception as a possible way in which to deal with family planning. And then Roe versus Wade, the decision about abortion, when first argued, was much more about the idea of privacy and whether or not an individual can seek an abortion as part of that family planning that was established in Griswold versus Connecticut in 1973. That was also a 7-2 decision. And the way in which the U.S. Supreme Court found the saying that there are penumbras, sorry, I have trouble with that word, is a zone of privacy that is created by the First, the Third, the Fourth, and the Ninth Amendments. The First Amendment, the right to freedom of speech. You should be able to speak with whomever you want. The freedom of association is certainly a key component to the idea of privacy. And then you add in that we also have the right for protection against illegal search and seizure. And so this Fourth Amendment protection against illegal search and seizure implies the idea that there are some things that are private, that are ours, that we get and the government can't take away unless it actually has a really strong reason to do so. And that strong reason has to be demonstrated by being able to go in front of a judge and asking for a warrant that then allows the government to come in and take specific things, and they need to lay out as specifically as possible where they're going to be looking for those things, what things they hope to find, etc. And if they can convince a judge doing that, then they would get that warrant, which allows them to do a legal search and seizure. They're legally able to search someone's apartment or your car or something that is personal property. The Ninth Amendment is the part of the Bill of Rights that was added in to deal with Alexander Hamilton's certain number of liberties. In that sense, it's saying basically the Ninth Amendment says there are some essential liberties that are also protected even if we don't articulate them. The Third Amendment is because the Third Amendment not used very often, and if you were a constitutional scholar and you specialized in the Third Amendment, you'd have quite a bit of vacation time, but it does play an important role in this idea of privacy, which is that the Third Amendment said that there will not be troops placed in your house during peacetime. That's the billeting of soldiers. That was done by the British government leading up to the Revolutionary War. And so it's a reminder that the Bill of Rights and the U.S. Constitution was a document that was meant to deal with specific political problems at that time. But you can also see the larger conception of saying, well, you can't put military in someone's house during peacetime is an indication that government officials should not be allowed to intrude on this private sphere. And so the combination of the First, the Third, the Fourth, and Ninth Amendments creates the right to privacy. And so it's important to take a look at the right to privacy. It's certainly linked to the idea of investigations into terrorism. And the textbook does a really nice job of talking about the ways in which the powers of the government increase that significantly and then might restrict the right to privacy. But it also does a nice job of explaining why privacy is so important and how it has been applied to a number of personal decisions as well as dealing with the war on terror. But what we see again is this trade-off that can exist, this right to privacy, which can be seen as a political liberty and has been in court, even though it's not explicitly in the Bill of Rights, can run up against popular sovereignty, the idea of making ourselves feel safer, and sometimes we ask it, or we don't ask the tough questions of the government, or the government feels compelled to take these actions because they want to demonstrate that they are dealing seriously with a concern that a lot of people are worried about.